the Federal High Court has adjourned indefinitely the trial of the leader of the proscribed Indigenous People of Biafra, Nnamdi Kanu, in the terrorism charges brought against him by the federal government. Justice Binta Nyako put off the trial indefinitely at the instance of Mr. Kanu, pending the resolution of the federal government appeal against the October the 13th judgment of the Court of Appeal that discharged him from the terrorism charges. The federal government appeal seeking reversal of the Court of Appeal's judgment is pending before the Supreme Court. Two other cases billed for hearing before the court were also put off indefinitely for the same reason. Meanwhile, Mr. Kanu refused to appear before the Federal High Court today. The refusal to honor the High Court was conveyed to Justice Nyako by the federal government's counsel, Mohammed Abubakar. He informed the court that all entities made to persuade Mr. Kanu were rebuffed. Judiciary correspondent Celestina Area joins me now for the latest on this development. Celestina, I know you were in court today, but at this point, for those who might be wondering all that has been happening and the different judgments, explain to us the judgments so far, and then what this means for Nnamdi Kanu.
Okay, yes. First off, Precious, the Federal High Court, headed by Justice Binta Nyako, struck out 8 out of the 15-count charge, leaving 7. But Mr. Kanu and his legal team went to the Court of Appeal to appeal that judgment. And the Court of Appeal squashed the entire charges, saying that the trial court erred to have stricken out 8 and left 7. So which means by that order of the Court of Appeal, Mr. Kanu is a free man. And but the DSS and the federal government appealed that judgment of the Court of Appeal, and they filed an appeal at the Supreme Court. So they made the Court of Appeal they had to file a stay of execution of that judgment. So what we have now is an appeal at the Supreme Court against the judgment of the Court of Appeal, which set Mr. Kanu free.
All right. So right now, we understand that he refused to appear in court. Do we know the reason why he didn't show up? Because the counsel to the federal government said all entities failed, all attempts to make him come to court failed. What do we know why he has refused to come to court?
Okay, well, his counsel, Michael Zeko, senior advocate of Nigeria, said the last time they visited Mr. Kanu, he was quite aware that today was the day to give the court an update as to how he has gone through his appeal at the Court of Appeal and the Supreme Court. He didn't tell them he wasn't going to show up today, and he's in the court of the DSS, so it's for the DSS to bring him to court. But the counsel to the DSS said that Mr. Kanu refused to appear in court today for reasons we don't know, and they said they tried all possible best to ensure that he was brought to court today, but he didn't show up. But to twist the whole issue around, surprisingly, the DSS noted that they have a fresh amended count of 7 counts against Mr. Kanu. But Mr. Ozekome noted that amended count charge, they have not been set, and they don't even know what is contained in the charge. But Justice Binta said, okay, irrespective of the amended count charge that the federal government has against Mr. Kanu, that they should wait for the outcome of the Supreme Court.
So, because this case has been going on for a really long time, and look for people who might be lost in all of the judgments, we know that there was like you said, also said earlier, High Court had discharged him of the terrorism charges, but the federal government is now appealing that judgment. But he was in court today for fresh amended charges, if I'm right. Now, what happens if the court, and I know that you cannot preempt the judgment of the Supreme Court or the appeal court, but does that mean that he's going to be in custody for a while, even while these particular fresh charges, are being decided on in court, or the trial is ongoing in court?
Okay, from what we gathered, the amended charge that the federal government wants to file or has filed carries the serial number of 2015. And the pronouncement by the Court of Appeal states that Nnamdi Kanu should not be tried on any charges or anything he may have committed before he left the country, because the way the federal government brought him back to Nigeria through extraordinary rendition is illegal, and it's in breach of the Act of Specialty. So if that is the charge the federal government wants to bring against Nnamdi Kanu, I would say it will not stand, because from what we see is looking at the federal government is trying to get something that will stick. They cannot approbate and reprobate at the same time. Okay, first of all, you filed a charge against him at the Federal High Court. And this charge, Precious, remind us that it was amended 7 times before he had to take his plea. And the Federal High Court now struck out 8, leaving 7. Mr. Kanu appealed against the 7 at the Court of Appeal. The Court of Appeal struck out the remaining 7, saying he's a free man, he should be set free by the DSS. The DSS now went to the same Court of Appeal to file a state of execution of that judgment, and now they've gone to the Supreme Court to appeal that particular judgment by the Court of Appeal. So if you cannot wait for that to be decided, you're rushing back to the Federal High Court to file another charge. What does it say? Why can't the federal government just wait and let that case be decided off first? But still, it's still an amended count charge of 2015. And the court has said anything that he may have done before he was brought back to Nigeria in an illegal way cannot stand. So the federal government has to just be patient and see to the end of that particular case at the Supreme Court.
We'll see how it plays out. We're waiting for the judgment from the Supreme Court. Thank you so much for keeping an eye on this story for us, Celestine Area.